Welcome to the Jack Stevens webinar, Utilizing Trusts as IRA Beneficiaries, Avoiding the Tax Traps. Your speaker for today's program is Jack Stevens. Operator assistance is available at any time during this conference by pressing #. A question and answer session will follow the presentation. You may send chat questions at any time during the presentation using the chat window indicated by a speech bubble icon located to the right of the presentation. I will now turn the call over to Jack. Please begin.
Well, good morning, everyone, or good afternoon. That's right. We're at noontime on this webinar. We normally do them mid-morning. How is everyone? Hope all is well, and thank you for tuning in. The reason we decided to do a webinar on this subject is because of the number of questions that we have had in this regard. Over the years, as you recall, I have implemented IRA planning into my estate plans, and in doing so, there are a lot of questions that have arisen. I had many questions back in the 90s, and as you recall, I wrote a book on IRAs, avoiding tax traps in your IRAs, that Kiplinger's retirement reports endorsed and got me involved in a lot of planning in that regard, because there were a number of attorneys that did not do this type of planning and did not care to do this type of planning. And what I found basically is that there's a significant necessity into implementing your retirement and IRA planning in the estate plan as a whole. And in California's community property state, we have used some technical arrangements such as aggregation agreements among spouses to utilize IRAs in the estate plan for federal estate tax purposes and to overfund the decedent's trust. I'm not going to get into that too much today, but it does have a radical effect on planning with the estate tax, especially if the estate tax is reduced to $1 million when this law sunsets December 31st, dropping from a $5 million exemption to a $1 million exemption. If that occurs, we will be back in the business of doing these aggregation agreements, probably to overfund the decedent's trust. And the reason being is that in a spousal situation, the surviving spouse normally inherits the IRA plus 1/2 of the trust assets, which typically puts them over the exemption amount for federal estate tax. So what we try and do is put more assets over in the decedent's trust on the death of the first spouse, so it reduces or negates federal estate tax because of the IRA funds in the surviving spouse's estate. A little bit complicated, but it's a necessary planning opportunity that we have utilized in the past, and again, we'll see what shakes out of the election and the makeup of Congress, and if the Congress acts on this law toward the end of the year. You will be getting an alert in that regard. I'll write an article on it, of course, and send it out via email. Today I want to address the living trust issues. We get a lot of questions on the living trust as a beneficiary of IRAs. And in that respect, there's a lot of confusion. There was a time when we had utilized trust pretty commonly as the beneficiary of the IRA. Not many problems. However, over the years, the IRS has instituted regulations in that regard, and there have been a number of cases that were decided in the court system, and there are various problems that pop up when we utilize the trust as the beneficiary of the IRA. And I want to go over some of those problems with you so you can recognize and try and understand them. And then we're going to move on to why we utilize an IRA designated beneficiary trust as a preferred route for the IRAs as beneficiaries. Living trusts, as you know, they are grantor's trust. When we transfer into living trusts any assets or funds, we still own those assets. And that's why it's called a grantor's trust, because we can amend the trust, revoke the trust, remove the assets, transfer the assets, whatever we want to do. It remains a grantor's trust, and it has broad powers in the trust to take care of debts, taxes. In fact, the trust language and provisions say that on my death, my trustee is to pay all debts, final illness, taxes, et cetera, et cetera, et cetera, and then the net of my trust estate shall be distributed to my heirs. Okay. That being said, the IRS indicated that a trust, if it did not have qualifying language in it, which most trusts don't. I review thousands of trusts annually, and very rarely do I ever see, and it's not because the attorneys are lazy, it's because they've just not gotten, or many of them have not been, or gotten familiar with some of the rules and regulations on IRA planning. But within the trust itself, it should have qualifying language to qualify the trust as a designated beneficiary. Designated beneficiary is the key term. Absent that qualifying language, the trust has there's no argument that can be made that the trust is a designated beneficiary for an IRA, and therein lies the problem, because it creates the estate as a beneficiary of IRA funds. If you look on the slide, that is number 2. If you create the estate as a beneficiary of IRA funds, you've got a real problem. Why? Because the IRS has promulgated a rule and regulation that if you designate the trust as an IRA beneficiary, you must use the shortest life expectancy for distribution. Let me give you an example. Let's say you have a child, you're benefiting a child and a grandchild, and as you're in your trust, as beneficiaries of your trust, and designate your IRA as to go to the trust and the beneficiary of the IRA. On your death, we look at that point as to what beneficiary in that trust has the shortest life expectancy. Well, we know your child has a shorter life expectancy than the grandchild, so we would say the child But wait a minute, because you have named the trust as the beneficiary without qualifying it as a designated beneficiary, and you have provided funds to pay for your estate's debts and taxes, the IRS takes the position that you have designated the estate also as a beneficiary because it is benefiting from IRA funds to pay your taxes, your debts, etc. So the IRS took the position that the estate is also a beneficiary of your trust, and the estate has no or zero life expectancy. Thus, it has the shortest life expectancy. As a result, when the IRA funds are paid to the trust, they must come out in the year of death or the year following death. So we don't have any way to distribute it over the life expectancy of the child or the grandchild because the estate has zero life expectancy. Therein is a major tax trap in using the living trust as an IRA beneficiary. If you have a significant IRA, one that you will not outlive, that you know is going to benefit children or grandchildren or whomever, the trust is really not your living trust. Your family trust is really not the way to go. And we will see how the IRA designated beneficiary trust is a better alternative. The living trust does not provide see-through status, which basically would allow for a payout of IRA funds over the beneficiary's life expectancy. And this is the case because it typically includes a general power of appointment. And in a general power of appointment, which is in all trusts that I've reviewed and seen, and it's typically there for the reason that you have whether you're single or a surviving spouse or married, you have the power through the general power of appointment to appoint your estate to whomever you wish, including yourself, your creditors, your estate, your parents, your older brothers and sisters, your older friends, or anyone that you wish. That general power of appointment brings in potential beneficiaries who can be older than your children or grandchildren, and that precludes a see-through status if the trust is not qualified. And therein lies a problem, too, because the general power of appointment, you should have that power in your trust. You want to be able to give your estate to whomever you wish. For instance, if you indicated at some point in your life that you wanted your children to receive your estate in equal shares, and then you had an older sibling that needed funds for health reasons, and you wanted to give that older sibling some of your estate, you can do that through your general power of appointment because it allows for continued flexibility in your trust. So we need that general power of appointment, but it works against the qualifying the trust as in getting it see-through status. So we can use your trust beneficiaries' life expectancies to distribute IRA funds in the future. And the whole essence of what we're trying to do here is when you leave your IRA, you want your children to take it over a period of time. you want, and the advantage of that is the IRA will continue to grow, and the less they have to take out, because they'll be taking minimum required distributions or more after your death, the less they take out, the less tax. So if they can spread it over 15 or 20 years, they're paying less tax annually. And the IRA is continuing to grow. And if you use a grandchild, they could have 40 or 50 years of life expectancy, even less tax and more growth. Now, what can be done with the trust? Can we qualify it as a beneficiary? Yes, we can. It takes a trust amendment to put that language in there. If you have IRA funds designated for a spouse and you want to use the trust, and I'm going to talk about why we would want to use a trust, as the beneficiary, we can amend the trust, put the qualifying language in there, and specifically preclude the trust from paying, using IRA funds to pay any debts or taxes. So that amendment would be helpful in allowing the trust to qualify as a designated beneficiary. I would recommend that if you have non-significant or nominal IRA money. If you have significant IRA money, I would highly recommend, and we'll see why in a minute, why I would recommend the IRA Designated Beneficiary Trust. Okay. This trust amendment that I talk about is not a major amendment, but it's something that is required if we name your family trust as a beneficiary or contingent beneficiary after the death of the spouse. The positives of using this amendment for your living trust, as I've said, it qualifies the trust as a designated beneficiary and will allow for distribution over the life of the oldest trust beneficiary. So the estate is cut out of the equation, and your oldest child or whomever you have as designating as a beneficiary of your trust, on your death, then distributions can then be taken out over the life of the oldest trust beneficiary. It allows the trustee to control the distributions. Why would we want to do this? Because believe it or not, I do talk to many of you that say, I have children that they're not sophisticated. They could be in their 40s or 50s, still have problems with money or creditor issues or whatever. We use that trust and that trustee to control the distributions to the beneficiaries. And that may be important in your family. Only you would know that. So if you want to minimize the effect of, say, a child or a grandchild totally depleting the IRA account after your death, and many do this, by the way, if they are named as the beneficiary on the IRA, they then can ask for a check to be sent and totally deplete their share of that IRA fund. And this happens quite often. If you don't want that to happen, and what you're doing is trying to control this in the future, maybe for their financial security in the future with the use of the IRA, then the trust would be a positive for that purpose. Also, if you have younger beneficiaries in the trust, IRA funds are going to be payable to the trust, then you may accumulate distributions for these younger trust beneficiaries, or for a trust beneficiary, again, who may not be sophisticated in this area, and you want to accumulate funds for them for later life or their retirement or whatever. So that would be a positive for this purpose. Okay, I want to move now from the family or living trust to the IRA designated beneficiary trust, which many of you have executed. What is this? This is a separate trust. It is separate from the family trust, the living trust. It is a separate document, so you don't be confused. It is not in your living trust. It's not part of the family trust. It is a separate trust agreement. Number one, it is a qualified designated beneficiary. It has that language already in it to become a designated beneficiary under IRA law. And what does that mean? What is that? How is that language indicated? It's valid under California law. It becomes irrevocable and must say so on the death of the account owner, the IRA account owner. All trust beneficiaries are individuals and identifiable in the trust agreement. And it states that a copy of the trust agreement will be provided to the IRA or retirement fund custodian within the time required by law after the death of the account owner. And that time typically has been moved from time to time. Usually it's by October of the following year. So there's plenty of time to provide the custodian, but that it specifically states that. And when we administer these trusts on the death of the account owner, we many times advise the trustee, or we send a copy to the custodian to fulfill this designated beneficiary requirement. The trust itself is one that precludes any payments for debts or taxes for your estate. And again, as I stated before, that's always included in a living trust because that's one of the purposes. We want to take care of debts, taxes, etc. out of the living trust before we distribute trust funds to beneficiaries. But in this trust, it specifically states none of the IRA funds can be utilized for that purpose. So it's already set up. It's arranged to be a qualifying designated beneficiary trust. Secondly, you may use this trust for conduit treatment. And what this means is that if all funds, minimum required distributions, or any additional funds are withdrawn by the trustee for a beneficiary, they must be immediately paid out to the beneficiary. That's the conduit treatment that I'm speaking of. If that's the case, and this trust is considered to be a conduit trust, automatically the oldest, we don't have to worry about any distributions going to the estate or an older person, older than the beneficiaries. We automatically get treatment for the oldest beneficiary designated in the trust, not counting contingent beneficiaries. The distribution will be taken out over that beneficiary's life expectancy. So we don't have to worry about anything else. That is going to happen because it's considered to be a conduit trust. The third advantage is the trustee has total control of distribution. And this again is very important for a lot of IRA owners because they don't. And now I'm talking about individuals, clients with significant IRA money that they know they will not outlive. They will be providing these IRA funds to children, grandchildren, or other beneficiaries. The trustee has control, and you may state in the IRA designated beneficiary trust exactly how distributions are to be made. They could be you could provide for education. You could provide for first homes, down payment on homes. Anything that you want to create, you can create, because the beneficiaries have no authority. They have no demand powers. They are merely receiving minimum required distributions, and then they can apply to the trustee for other funds for health, education, support, maintenance, and again, like I said, if they're purchasing a first home or whatever, and the trustee can provide those funds to them. This trust also provides asset protection from creditors. So if you have beneficiaries, children or grandchildren who have creditor issues, or maybe they're in a profession in which they could be sued, are there potential divorce issues with the children or grandchildren? This isolates the funds from those types of potential creditors, including judgment creditors. If you have younger grandchildren, we can accumulate for those younger beneficiaries to hold funds for their education and pay out for high school, college, and postgraduate work. Also, and very importantly, it avoids revealing the family trust to third parties. Under California law, we have a requirement that family trust, on the death of the creator of the trust, we must provide statutory notification to beneficiaries or heirs that they have an opportunity to see the family trust and any amendments thereto. This particular trust does not provide for any of the family trust funds because we're only dealing with IRA funds itself. So we're not revealing the family trust to these beneficiaries. Now, number 7 is huge, and it's a little bit technical, and it's where a lot of problems potentially arise with custodians. Allows the opportunity, and I phrased it like that, it allows the opportunity to distribute IRA funds into separate subtrusts of beneficiaries. Why would we want to do that? Let's go back to the IRA rule that if you have a qualifying designated beneficiary trust, it will allow for distributions to be taken out over the life expectancy of the oldest trust beneficiary. Why? Because it uses the shortest life expectancy. The oldest trust beneficiary has the shortest life expectancy. If your trust qualifies, we get that. We've got that. It's a done deal. However, what if we have variances in ages of beneficiaries that are considerable? A child. Maybe you had a child from a prior marriage who are in their 40s, and then you remarried and had another child who is in their 20s, early 30s, and then they had a child, and you want to designate a grandchild who's maybe in their teens or even younger. Look at the variances of ages. If we do get the trust qualified as a beneficiary and distributions after your death are tied to the oldest trust beneficiary, let's say someone in their 40s, that grandchild is tied to distributions based on the oldest trust beneficiary's life expectancy, which can remove many, many years of distribution for that grandchild or a younger child. And that is obviously a disadvantage for that particular individual. Thus, if I have a child who's 45 with 40 years of life expectancy and a grandchild that's 10 with 75 years of life expectancy, it's a great disadvantage to that grandchild to tie their distribution to the oldest child, because they lose out on about 45 years of IRA accumulation in their share of the IRA funds. So we followed, several years ago, I started creating sub-trusts as the beneficiary of the IRA, following what is known as a private letter ruling by the IRS. A private letter ruling is when one taxpayer requests a ruling on for their interests or whatever they're seeking to get a decision from the IRS, and it is binding for that taxpayer. However, the IRS rules, if they rule in their favor, that taxpayer can rely on that private letter ruling and go forward and not have to worry about any repercussions from additional taxes or whatever they're seeking in relief. We look at those private letter rulings, and although you can't rely on the private letter ruling for let's say X taxpayer, it gives us an idea of how the IRS may rule or promulgate a regulation in the future. So using a private letter ruling of several years ago, I started separating my beneficiaries into sub-trusts, a sub-trust for each beneficiary within the IRA designated beneficiary trust. Why? Because that private letter ruling stated if there were separate accounts for each beneficiary or separate sub-trusts within the trust, they could take distributions over their individual life expectancy. So if I have a child, an older child, another child who's 10 or 12 years younger, and a grandchild, I make those sub-trusts the beneficiaries of the IRA shares. Based on the fact of that private letter ruling, I can then argue, if there's an issue, that that grandchild should have 75 years of minimum required distributions while allowing that IRA to continue to grow, while the older child may have only 40 years. That means less tax and more growth, and allows the opportunity to distribute over life expectancies of the grandchildren without tying them to the older generations. That's what I attempt to do. And I say attempt because we take advantage of the private letter ruling, but there's no guarantee that because we're not obtaining private letter rulings for each of you. They're very costly, incidentally. But it gives us some insight out how the IRS will rule if this becomes an issue because they allowed it before. And what this does, it creates a tax break for the younger generation, even if you have children that are 10 or 12 or 14 years apart. It benefits that younger child and allows for more IRA growth. And it also allows for more organization of the IRA funds because we have separate shares in separate subtrusts for each beneficiary. It's a little more technical to do. That's why the IRA designated beneficiary trust is a little more technical animal, so to speak. But with those of you who have significant IRA money, it can be a tremendous tax benefit for your trust beneficiaries. If your trust beneficiaries are close in age range, let's say you're benefiting only children, and your children are a year or two apart, it would make no difference. You don't need to do that because the difference in your age range may maybe be 3 or 4 or 5, 6 years, and it has little impact on the life expectancy for each child. But those of you who have a range of beneficiaries and ages, it can have a significant benefit for the younger ones. Okay. I want to go to the next slide, and let's talk about the negatives of the IRA designated beneficiary trust. It requires a second trust and with associated fees. So we're not amending your family trust, as I've indicated before. We can do that with an amendment, as I indicated early on in the presentation. But if you've got significant IRA money, I would use an IRA designated beneficiary trust, and it's a new trust. It's a separate trust, and it has fees associated with its creation. IRA owners, you, the account owners, must file customized IRA beneficiary forms and follow up with the IRA custodians. I create those as part of the IRA designated beneficiary trust. I customize your beneficiary designations, the forms. You then must follow up. I can't call for you. They won't discuss these issues with me. As the IRA account owner, you're the person, and must make sure that your custodian accepts if you're using subtrusts. The IRA custodians have accepted the IRA designated beneficiary trust, but many are unfamiliar with the subtrust arrangement. And I can tell you in the past, and those of you that I have done these trusts for, we sent the letters off and they never responded. The custodians would not acknowledge that they received the IRA designated beneficiary forms, and you must follow up with them. You are the boss of your IRA money. And what I recommend to clients is that if you don't get a response or they do not acknowledge that you're setting up these subtrusts as the beneficiaries of the IRA money, that you have a very strong heart-to-heart talk with your IRA custodian and say, look, the IRS has allowed this. We want each beneficiary to take it out over their individual life expectancies, and we expect you to accept it and acknowledge it in writing. And that's what I do. I send it out, and I have them have a place for them to sign and acknowledge receipt and acceptance in writing. If they don't do that, you have the option of saying, okay, I'm going to move that $1 million or 600,000 or 700,000 or $500,000 or whatever you have to another custodian. That typically opens their eyes. And what I have found they will do is they will discuss this with their legal department and get back to you with a positive response. But many times you have to, it's like I'm handing the ball off to you and you must carry the ball on these IRA designated forms because they're customized for this purpose. It's a negative because you're going to have to take a stand and a position with your custodian to accept them. Now, we don't put these in the living trust. When we amend the trust, the family trust, and qualify it, I do not put sub-trusts because the living trust is really not the vehicle to do it. But I do put them in the IRA designated beneficiary trust. And once that's sent off, I will promise you, you will not hear, many times you will not hear from the custodians or not hear from them for a long time. You're going to have to force their hand and say, look, we sent those IRA beneficiary forms to you. We have not received your acknowledgement back in writing. What's going on? Because this is the way we want our IRA money to be distributed over individual life expectancies for our children, grandchildren, etc. So, in sum, the advantages of the IRA DBT is you've got more organization, you've got allows for subtrust to distribute over individual life expectancies, and you have creditor protection for the IRA money for your beneficiaries. And it's a much better vehicle to utilize for IRA funds. I show about 15 minutes remaining. I would like, if you have any questions at this point in time, if you can use the bubble for chat questions, or I think they've opened up the line if you have a question, or will open up the line for questions over the telephone. Also, I have a concluding slide here. If you want a consultation regarding anything that I spoke about today regarding using your living trust for an amendment or a IRA designated beneficiary trust, the fee is $195. If you do go forward and do the work, we will apply that consultation fee toward the legal services of either an amendment to your trust for IRA funds or initiating or creating an IRA DBT. Also, those of you that have IRA designated beneficiary trust presently, there are some technical changes that we need to put in your IRA DBT. There is not a huge change or amendment, but there are some changes that we need to implement into your IRA designated beneficiary trust. I want to conclude by stating that this is a very beneficiary forms are very, very important. There is a huge amount of litigation going on in the court system because people have not taken care to correctly designate beneficiaries for IRAs and retirement plans. They assume. I hear the word assume. When I ask the question to clients in the office, who have you designated as the beneficiary of your IRA? Well, I assume I've designated my wife. I assume I've designated my trust. I assume I've designated my children. Assumptions are out the window. We cannot assume. If you don't know for sure you request a copy of your designated beneficiary forms from your IRA custodian. Get it in writing. Look at it. See how it reads. If you have designated children after your spouse, or if you don't have a spouse, if you've designated children, are they appropriate to be recipients and beneficiaries of your IRAs as an individual? Do they have creditor problems? Do they have family or divorce issues? Do they have lawsuit issues? If they do, you may want to rethink that. Also, they must treat if they're individually appointed or designated, they must treat it as an inherited IRA and add their name to the IRA after your demise and leave your name on as the account owner. If they take your name off, the IRS considers that a distribution in the year that they do that. If they remove your name for the entire IRA, that means a tax on the entire IRA account that year. And I have seen that time and again when inexperienced or just people who do not have this kind of information go to the bank and say, Mom is now deceased, Dad is now deceased, I'm the beneficiary of the IRA, put it in my name, and that's going to be my IRA. And the banks do it. And what they do, they report to the IRS that a full distribution of the entire IRA has been made in that year, and that means tax on the entire IRA. So again, if you've got a trustee that's controlling the situation, that is not going to happen. Okay, I'm going to turn it over to you all for questions. And the operators on the line, you can call in or you can use the chat. Are you there, operator?
Yes, ladies and gentlemen, if you're dialed in on the toll-free bridge, you can press 7# on your phone now, and you'll be queued to ask a verbal question. Also, you can please continue to send chat messages using the chat feature on the web presentation. We currently have a couple of questions in the chat when you're ready for those.
I'm ready.
All right, the first question, what is considered significant IRA money in correlation to trust amendment?
I get that question all the time, and it's a very good question. Significant means what part of the IRA money makes up your estate. If the IRA funds make up at least a third or more, I would say that's pretty significant. For instance, if I have let's say a $600,000 estate and you've got $200,000 in IRA money, then anything that amount and above, I think it's significant. Also, significant means I'm at a state that I'm not going to utilize all these funds during my lifetime. I know my beneficiaries are going to receive some IRA money. Then you should start thinking in terms of how do I want to make sure this is distributed properly and appropriately to the beneficiaries. Next.
Approximately how much are significant IRA funds that you would recommend warrant a separate IRA DBT? And the questioner has an AB trust. Can this be amended if we decide not to have a separate DBT?
Okay. I'll take the first part of the question first. If you're going to set up an IRA DBT, I would think you would want a minimum of $500,000 to make it a viable planning opportunity, an IRA or retirement fund money. And at the same time, I would say 500,000 or more. Um, Amending an AB trust, yes, we can amend an AB trust for that purpose. And again, you don't have the protection, you don't have the organization of an IRA DBT, but we can amend an AB trust as well as any living or family trust to qualify it as a designated beneficiary trust to get the oldest trust beneficiary designated for distribution purposes. Next.
That is all the questions we have queued at this time.
I have one that please clarify again how the estate is designated as a beneficiary. The estate is it's not so much designated as a beneficiary as the IRS has ruled that the estate is a beneficiary by virtue of the fact the client and clients do this all the time. They just say, I'm designating the trust as a contingent beneficiary after my spouse, or if it's a single individual, I'm designating my trust as my primary beneficiary. They don't qualify the trust. They don't delete or preclude, have any preclusionary language that says no trusts or IRA funds can be utilized to pay my debts or taxes. And on view of that arrangement, the IRS will say you have made the estate the beneficiary of your trust because you're benefiting the estate by paying your debts and taxes, which your estate is liable for. Thus, it's a beneficiary. As a result, the estate is a beneficiary and has no life expectancy. Thus, all IRA funds will be taxed in the year of your death or the year after your death. It'll come out in that 1 year, and it'll be distributed. Not distributed. It'll be considered taxed in that 1 year, and that is a huge, huge tax trap. If we have no other questions, I want to thank everyone for joining me. I look forward to seeing any of you. You can call the office. I think it will be a survey sent out if you're interested in a consultation. Also, we would ask that you fill out the survey. We'd like to know how you enjoyed this webinar. And also put on there if you would prefer the noon time or the mid-morning time. We usually do them at 10 o'clock. We tried this one at noon just to see how people like it. If you have any input, we would gladly like to hear from you. Also, if you want to set appointments, you can call Natalie and tell her that you're calling as a result of the webinar in this regard. Thank you all again for attending, and look forward to seeing you soon. Bye-bye.
Thank you, Jack. This concludes today's Jack Stevens webinar. Thank you all for attending.
The moderator has ended the conference. Goodbye. Thank you for calling.